Hello, everyone. Thank you again so much for joining us for our discussion today. This is actually the inaugural session of a new series that the healthcare practice is kicking off here at Vorys. We are looking to try a format that's going to be a little bit more conversational and a little bit more manageable in terms of time than the traditional webinar. As you noticed, it's a half an hour session today instead of the full hour, so hopefully that's a little bit more conducive to your schedule. But we would love your feedback after the session today on how you liked what we did here and what we might be able to improve, so please feel free to reach out. So starting off, I'd like to introduce our speakers. First, we have Jolie Havens, partner in the Vorys Columbus office and the chair of our healthcare practice group. Jolie practiced nationally, assisting clients across the spectrum of healthcare providers, and she frequently publishes and speaks on various topics related to healthcare reimbursement and compliance, as well as healthcare reform, policy, et cetera. Next, we have Elizabeth Smith, who's a partner also in our Vorys Columbus office and a member of our litigation group. She has extensive experience in business, commercial, contract, employment, occupational disease, intentional torts, and public law litigation. We really appreciate her sitting down to discuss the implications of cannabis with us this afternoon. And as Mallory mentioned, my name is Mairi Mull. I'm an associate in the healthcare group, and I currently practice in the Vorys Pittsburgh office. So to start off, I'll turn it over to Elizabeth to discuss key legal developments related to cannabis at the federal and state levels.
Thank you, Mairi. Well, there is a fair amount happening on the federal level. We will see, though, if really any of it comes to fruition. Obviously, as we all know, marijuana as marijuana, or otherwise referred to as cannabis, remains illegal under federal law. Obviously, people are aware of certain criminal risks associated with that, but the question becomes, for those who are in states where medical marijuana or recreational marijuana is legal, and medical marijuana is legal only in Ohio, the question becomes, what is the interplay between the state and the federal government on that? I think putting aside criminal ramifications, I think for those who are engaged in business, and it would also apply to those in healthcare, but any type of business arrangement, the caveats are this. The issues that we're seeing arising are primarily those involving cases brought now in federal court. And what will a federal court and perhaps even the state court do in regard to enforcement of the rights, the private rights between parties? To be more specific, the U.S. Bankruptcy Court on a number of occasions now has dismissed bankruptcies that have been brought by those who are engaged in the medical and or recreational marijuana business. If you've had a dispensary, you file bankruptcy, you're not going to be entitled to bankruptcy protection because that is a federal regulatory, federal legal system, and the federal courts will not recognize it. That creates risks. If you're a landlord and you have a dispensary client, dispensary goes bankrupt, you're not going to have a claim. So that is a very significant issue. The question will be whether federal courts will enforce contracts. So as you move through your work and starting to do business with those who are engaged in this business, you have to be cognizant of the fact that you are engaged in you are working with those who are engaged in a business that is illegal under federal law. That may entail risk of forfeiture, may entail your having received funds that have been generated through an illegal enterprise, as well as not being able to seek the protection You're not going to be able to use the tax laws in the event that there are certain costs or expenses that you want to deduct that have to do with a medical or recreational marijuana business. That, again, is just sort of an example of the type of risks that are created by this dichotomy.
This is Jolie. I would say there are also specific risks to healthcare providers. As Elizabeth mentioned, in Ohio, we have only medical marijuana that is legal, and there are still a lot of open questions regarding exactly how this is going to be fully rolled out and operational from the healthcare provider perspective. Interestingly, when this was all being created, providers didn't really have as big of a seat at the table as one might have thought. So now we have this framework where, as Elizabeth mentioned, we have this real disconnect between state law and federal law. So for providers that are going to engage in, treatment with medical marijuana, or they're going to allow patients or clients or consumers, depending on what terminology you use and what area of the industry you're in, if it's outpatient care, are you going to allow them to bring it on site when they come for treatment? Or if they are, in a home and that is part of their treatment, are they going to be able to maintain it there? And the reason that brings up issues is because there are certain things that are permissible from a state law standpoint, but then these providers also have federal credentials. You're going to be potentially enrolled in Medicare, enrolled in Medicaid, have DEA credentials. So it sets up, a really, really challenging situation for providers to figure out how to navigate these issues to potentially take advantage of opportunities that exist for treatment from a state law standpoint, while also, potentially putting at risk some of these federal credentials. Now, I will say we have not seen the government take an aggressive view on this. There are other states that have had, for example, medical marijuana programs that have been in place for much longer than Ohio. We have not seen, CMS go after Medicare providers in those states. That being said, we've got obviously a lot going on at the federal level with the administration. As Elizabeth, I think, will mention, the federal government's position on some of this has changed over time. So I think while, at least right now, it looks like the likelihood of enforcement or action against a healthcare provider at the federal level is probably pretty low. The magnitude is obviously incredibly high, associated with potentially losing, enrollment and participation in Medicare, Medicaid, and that you could also have implications under, any private insurance network agreements that you have as well. So, providers find themselves in a very, very precarious spot, depending on what role you are going to be taking, if any, in terms of this treatment and getting involved in this new industry.
And let me just piggyback very quickly on that. One area that we're not going to address in depth here is the employment area, but let me point out that, again, another example of a federal law, the Americans with Disabilities Act, because it is a federal law, does not require an employer to accommodate for the use of medical marijuana. So companies can still have drug-free workplaces, and that is true even under Ohio law. So the question becomes, when you are engaged in business and you are trying to figure out your policies and what you want to allow, et cetera, and this then dovetails into what Jolie said, you want to look at to what extent are you engaged in federal contracting and to what extent do you receive federal funding or federal benefits. And I think maybe that wraps that up. And I'm willing at some point to, again, go through what the federal government sort of has pending right now, but that may be for a later time.
That would be great. And as Elizabeth mentioned, we are going to do a Dazed and Confused series, if you will, of webinars. So stay tuned. The second in our series is going to be focusing on employment-related issues, because obviously wherever you sit relative to this industry, whether you have healthcare provider-specific issues, you're going to have potential employment-related issues, and we want to make sure that we go over those. Mairi, I'll kick it back to you.
Great, thank you. Jolie, before we move on from the federal aspect, would you mind discussing a little bit about the FDA's position with respect to cannabidiol?
Oh, sure. This is also something that's unique. All the buzz lately is CBD and various claims about, the therapeutic effects associated with that. And I think there's a lot of misunderstanding regarding, what CBD actually is, whether it's legal, where it can be sold, all of those things. So previously, prior to last summer of 2018, all medical marijuana related products were Schedule 1 for the DEA, which meant essentially subject to and conducive to high levels of abuse and basically no medicinal purposes in the eyes of the DEA. And that was cannabis, across the board. Then last summer, we got our first FDA-approved drug that was derived from CBD. And CBD, for anyone who doesn't know, that's the non-psychoactive component of cannabis, which is contrasted with THC, which is the psychoactive component that gets you, quote-unquote, high when you're talking about marijuana. So in the summer of 18, the FDA approved a drug called Epidiolex, and it's for the treatment of certain rare seizure disorders. And as I said, it's the first treatment that is FDA approved and derived from cannabis. The quandary, though, was all medical marijuana-related products were still Schedule 1, which meant it could not be put into the market and actually, distributed and sold for treatment. So then this issue got kicked back to the DEA to look at this issue and potentially reschedule Epidiolex, which would then allow it to be made available to the public. A few months later, in the late 2018, the FDA did, or the DEA did just that. They moved Epidiolex to Schedule 5, which means it can then be brought to market for purposes of treatment. But the important thing about this is that the change that was made was only with respect to Epidiolex. All other CBD remains subject to essentially the federal prohibition. Now, the asterisk I will give you with that is CBD that is derived from hemp. And hemp, if we're going to differentiate it from the rest of cannabis, is just essentially cannabis with a THC content that is less than 0.3%, which means essentially you can't get high off of it. And it's viewed as being used predominantly for industrial and commercial purposes, clothing and other sorts of things. So if you've got CBD oil that is derived from hemp, it is not subject to the federal DEA prohibition, but it is subject to the FDA regulatory scheme, which means that it is still going to be illegal, even if it is hemp-derived, if it has not been approved by the FDA. And as I said a couple of minutes ago, the only CBD-related drug that has actually been approved by the FDA is Epidiolex. So all of these, CBD lotions and oils and, other concoctions that we're seeing, they are, if they are not, at least in Ohio, if they are not sold in the dispensary, they are effectively illegal in some manner at the federal level.
The medical marijuana dispensary.
Yes,
yeah.
Yes, absolutely. So I think there's been a lot of confusion around that and, different voices coming in on that because you've had, the FDA, you've had the DEA, and then obviously the state level piece as well, which we'll touch on. But long story short, if it's not Epidiolex and it's not CBD that you are getting from a medical marijuana dispensary, pursuant to a recommendation, then it's illegal to sell and it's illegal to buy and possess. So I think that's a bit different position than what many people are thinking when they're reading a lot of the discussion that's out there on CBD.
And that, so jumping into this, I think that what has been done in regard to CBD through the federal Farm Bill is sort of another instance of the federal government starting to take a look. And even though that was not marijuana, it is sort of indicative of now what is also happening in the cannabis marijuana area under federal law. Obviously, things are moving slowly. There's no surprise there. It's Washington, D.C. But there was a recent amendment put into place, putting up for vote, that would keep the Justice Department from using its funds to prevent states from implementing their own laws that authorize the use, the cultivation, et cetera, of medical marijuana. That is, they're looking for something that is going to recognize protection for those states now that have put into place their own state regulatory process, a recognition that the state, this may be more of a state issue than a federal issue. There is a measure that's been introduced to prohibit the Justice Department from prosecuting or penalizing Department of Veteran Affairs workers for filling out paperwork in regard to the use, distribution, et cetera, of medical marijuana. There is also, I guess probably most importantly, there's the Food and Drug is taking on I guess, and as well as the Department of Agriculture, has been charged with looking at how do we deal with hemp and how do we measure the THC content and to make sure that the quality control is there. For the Food and Drug Administration, they're looking at what it means to process to make sure that there is a safe level for conventional foods and dietary supplements that do contain CBD. Let me also say this, that there are efforts to make marijuana legal generally that are in play. Senator Booker has a Marijuana Justice Act of 2019 to do just that, and there is also the legislation that's been introduced by Senators Warren and Gardner, both sides of the aisle, the States Act of 2019, to leave legalization up to the states. Importantly, there's a banking law that's being considered. I think it's still or just coming out of committee that would allow banks to accept deposits and otherwise conduct banking activity. Again, another risk for those dealing with those in the marijuana industry is that banks will not take funds that they know to be derived from this federally illegal enterprise. But I would say that U.S. Attorney General Barr, who is personally opposed to the legalization of cannabis, has stated that he recognizes that the legalization in 33 states and all of the legal issues that now that exist is, quote unquote, an intolerable situation. And he is considering endorsing the States Act of 2019. That is a different position than was taken by AG Attorney Sessions, who actually eliminated a memo that the Justice Department had followed for a number of years that did not prosecute in those states where marijuana was determined to be legal. So stay tuned because it is an ever-changing landscape. But my guess is that there are enough interested parties out there challenging Congress to do something about this, given that the industry is a multi-billion-dollar industry in this country.
Great, thank you. I know we've touched on this somewhat already in our discussion, but is there anything further either one of you would like to comment on at the state level?
Well, I can address this very briefly that under Ohio law, and Jolie mentioned this, that while hemp has been made, quote unquote, legal under federal law for, I guess, a limited purpose at this point, under Ohio law, it is still considered to be within the definition of marijuana and therefore subject to the regulations that govern the medical marijuana industry. and that you cannot get CBD oil regardless of what the THC content is without going through all the necessary steps, being a registered patient or caregiver, going to the recommending physician, and then ultimately purchasing it from a state licensed dispensary. The significance of that is there has been CBD products seized in this state from retailers by the pharmacy board. So it's, I think they did that to make sure that people knew that they were taking control of it. So that is not insignificant that they actually went in and seized, I understand, quite a large amount of CBD containing products.
Yeah, and in addition to that, I know at least in one instance earlier in 2019, an individual who was pulled over in a traffic stop and was found to have CBD oil in the car was also criminally charged with that because, again, CBD is treated as a drug, even though oftentimes it is discussed as though it's more like melatonin, you know, or something that we could buy over the counter. It is still very much regulated.
And even though the FDA says it's not, it doesn't have any drug effects, but
exactly,
it's very confusing.
Exactly, it is very confusing. I would say beyond that, in terms of just state level issues, I think one big question that's out there because we haven't seen it tested is for physicians that go and get the certificate to recommend. It is added on to their underlying medical license, okay? I think a lot of people think that it's very, very simple to obtain the certificate, and in some respects, comparatively to getting your medical license, it is. But in order to be able to retain it, you have to meet certain requirements under Ohio law, which includes, you know, a relatively minimal continuing education requirement, but some considerably more robust documentation and reporting requirements. And documentation requirements are sort of the bane of any healthcare provider's existence because they're very, very technical, oftentimes don't make a lot of sense in practice and can be something that we can get caught up in easily. What we don't know is if we have a physician who does not, after obtaining the certification, meet all of the requirements and is therefore brought before the medical board for non-compliance, do they just lose their certificate to recommend, or does that have any sort of impact on the physician's underlying medical license? Similarly, for healthcare providers that employ or contract with physicians, you know, is there the potential for collateral damage, if you will, if you employ or contract with physicians that have this certificate to recommend and then don't otherwise meet the requirements to maintain it? Again, just an open issue, but certainly one that, depending on how the medical board operationalizes that and carries it out, if and when it will inevitably happen, could result in some potentially serious collateral consequences. And right now we have a few hundred physicians in Ohio that actually are certified to recommend.
I think it may be worth noting also with respect to the hemp and medical marijuana distinction that there is currently a bill moving through the Ohio General Assembly that would adopt the same distinction that is currently in place at the federal level under the 2018 Farm Bill between marijuana generally and hemp, which would resolve some of the discrepancy currently between state and federal law. So we are running a little bit short on time, and we have a question that I would like to pose to our speakers before we close today. So the question is, does the proposed federal amendment only deal with medical cannabis, or does it also protect states that have recreational programs?
You mean to legalize marijuana?
I believe so.
To leave the bill that says to allow it up to the states to legalize it? I believe it's, if what I'm not exactly sure which amendment, but I believe that and I'd have to take a closer look at Senator Booker's law, which I frankly don't think is going to go anywhere. But I think looking at the States' Rights Act, I believe it's going to, at this point, and I really frankly don't know whether it's both. my guess is it's probably at this point going to leave it up to the states to decide whether they want to do one or the other. I think it's going to be hard for them to turn back the clock on those states where they have already allowed it for recreational purposes.
And
I would just add in, oh, go ahead, Mairi.
With respect to the Department of Justice memo, that would apply to both the recreational and medical?
There's no memo, I don't believe, at this point by the Department of Justice. The Cole memorandum that was what should I say, repealed or
rescinded or whatever.
Yeah, rescinded is the right word, by AG Sessions, did not make a distinction, but it just talked about a regulated program. And I think that's essentially where people pushing for this are coming down, that if a state has a highly regulated program, that is what they're going to say, okay, state, we leave it up to you because you have shown it's a highly regulated program that will not allow crime and violence and folks who are should I say in the black market or whatever to be engaged in this. And that's the concern, is to bring it within a regulatory system that works. And I guess if you were asking about what AG Barr has said, I don't believe he's put that in writing. I believe it was in a speech that he gave.
A couple of other things that I was just going to mention while we were going to let some other questions flow in would be, I've had some experience working with lots of different providers across the industry on compliance issues. And I would just encourage those of you who have not thought about that yet from sort of the healthcare provider angle as perhaps distinguished from the employment angle to give some thought to that and sort of where you sit in that industry. Do you employ physicians or contract with physicians that are recommending? If so, do you have malpractice coverage associated with that? Traditional malpractice coverage policies would not cover the recommendation of medical marijuana. There are some specialty insurers that are getting into the space to cover precisely that scope of services. But I have also heard from a couple of clients who have been assured by either their brokers or their insurers, oh, no, it's covered. And my advice back to them has been, I really think you need to look at the policy, because the issue here is sort of also tied into the fact that there is not a lot of research that has been done on the interplay between medical marijuana and other sorts of treatment. In fact, legally speaking, historically, it has only been the government that has been able to do research with respect to treatment efficacy and medical marijuana. So because of that, we don't know nearly as much about how medical marijuana interacts with other modalities of treatment, drug interactions, things along those lines, as we do about other treatments once they typically come to market. Epidiolex being FDA approved would be, the one exception to that. But I think, that brings in professional liability considerations, that brings in informed consent issues. So let's say you do have someone that you are treating that, is getting on a medical marijuana regimen, perhaps even through another provider, and then you are providing another service to them. Does your consent form that is signed, explicitly state, you are engaging in this treatment with the understanding that we, the provider, don't necessarily know what all of these interactions are, and that we can't necessarily fully take that into account the way we might other sorts of ongoing treatments. So informed consent and malpractice are two potentially huge issues. Beyond that, if you haven't considered it, think about, if you're an outpatient provider. Let's say someone who is on a medical marijuana treatment regimen. When they come for treatment, can they bring their medical marijuana with them in their purse onto the premises? Or could their caregiver bring it with them? Are they allowed to use it on premises? If it's more of an inpatient or residential program, someone comes to visit, can they bring it with them? There are just a host of issues like that, that even if you're a provider that doesn't necessarily consider yourself to be kind of squarely within within that part of the industry from a treatment standpoint, there are a host of issues that you're going to want to think about.
So at this time, if you have any other questions, please feel free to type it in the private Q&A box. We can address them now or later.
And I would just sort of as a little wrap up, just dovetailing on what Jody has said, this is many times all of this industry involves many of the same business concerns that any other business has, and you're going to run into issues of a lot of risks out there. The risks that are involved with the intoxication, the risks involved with edibles, as Jolie mentioned, with insurance, with products liability, with false advertising, human resource issues,
Banking,
trademark, patent, misappropriation, nuisance issues. The list goes on and on and on. So with that being said, there's much to know. Oh, okay.
We got a question asking if we had the names of any of the specialty malpractice insurance companies. We do have those names, and if you would like those, please feel free to email us, and we can send those to you directly. We don't necessarily have personal experience with those carriers to this point because it's, again, very, very new, but we'd be happy to share that information with you.
Well, at this time, there are no more questions, so we'd like to thank you for joining us today. Should you have any questions after our call, please feel free to reach out to any of the attorneys that spoke today. This concludes our program. Thank you so much.